SJC-11499, Commonwealth v. Matthew J. Pike.
Good morning. May it please the court, my name is Diana Cowie McDermott, and I represent the defendant on appeal. At trial, it was the Commonwealth's position that the defendant, an unclassified sex offender, was required to give the Barnstable Police Department notice prior to his change of address. On appeal, the defendant argued that there was no such requirement. The appeals court agreed with the Commonwealth. Now, on appeal, it is the Commonwealth has conceded that the defendant was not required to give notice to the local police department. So essentially, the Commonwealth has, and the Commonwealth goes on to say that the defendant failed to register and he did not give notice to SORB. I would respectfully suggest that the Commonwealth's argument is not properly before the court. They did not raise this below. They did not raise it at the appellate level, and they are now raising it for the first time. There's obviously a due process issue. So I would suggest to this court that the Commonwealth's argument should not be heard and is not properly before the court.
If we agree with you, then what would happen?
If you agree with me, then the Commonwealth's case falls apart and you should rule in the defendant's favor.
And then would that prevent them from then filing an action against the defendant for failure to register with SORB?
No. There is no evidence that the defendant failed to give notice
Would
to
that
SORB.
prevent them from filing an action? That's my question.
Yes, I understand. Yes, they would be prohibited from doing that.
I thought that your argument below was the sufficiency of the evidence.
Yes, I argue that the defendant's motion for required finding of not guilty should have been allowed because there was no evidence that the defendant failed to give notice to the local police department, which was what the Commonwealth argued. And that motion was denied.
I thought the issue was about a change of address to SORB, no?
Yes. So let me just make that clear, that my argument was that the Commonwealth's argument was that the defendant moved and he should have given notice to the local police department prior to moving.
And
he did
said
not.
nothing about SORB?
Correct. At trial, there was nothing about the defendant's requirement to notify SORB prior to his move. That's correct. For the first time on appeal, now in this court, the Commonwealth is arguing that the defendant was required to give notice to SORB, 10 days notice, prior to changing his address. And my argument to this court is that argument is not properly before the court because it was never argued below. So there obviously is a due process issue. And I would suggest that the Commonwealth should not be able to advance its argument now that the defendant failed to register because he did not give notice to the SORB when he moved.
You're distinguishing between failure to register and failure to give address.
The crime of failing to register, of course, there's more than one way to violate that offense. One way is when a sex offender moves, when he changes his address, he must give notice to SORB 10 days prior, or he must give notice to the SORB 10 days prior. The Commonwealth argued below that he was required to give notice to the police department. They concede now that there is no such requirement. So the issue is whether or not he...
Wait, but wasn't he told that he had to register?
The Commonwealth relies on two pieces of evidence for that position, and my response is that evidence is not good. The probation officer testified, I told the defendant that he must register with the SORB and he must notify SORB of any change of address.
But wasn't that the issue that was litigated, whether or not he was living at a different address?
Yes, because part of the violation is the sex offender changes his address.
Had he ever registered?
Yes, he was
Okay, so,
fully,
and
properly
and
registered.
the issue at trial was whether or not he had changed his address, wasn't it?
In part, whether he changed his address and did he give notice at trial
To the police department.
to the police department. Now, in this court, the Commonwealth persists. He moved. We concede he did not need to give notice to the police department, but we now say at the SJC, he was supposed to give notice to SORB 10 days prior. So they concede he was not supposed to give notice to the police department because there's nothing in the general laws that dictate that requirement.
Don't all those go away if you prevail on your other argument that there wasn't
I'm sorry?
Doesn't all of that go away if he didn't move? If there's not enough evidence of that?
There is no evidence that this defendant moved.
But wasn't that the issue at trial?
That's the issue.
Whether or not he moved?
Yeah.
Yes, because that's an element.
And your position was that there's insufficient evidence offered by the Commonwealth that he moved,
Yes.
right? And
Yes.
if there was insufficient evidence, that's the end of the story.
Yes, correct, because that's one element that can't be made out by the Commonwealth. Yes.
And that was fully litigated in the trial court, whether or not he moved.
Well, that was the, was it
And
fully
you're claiming that that the Commonwealth did not produce enough evidence that he did move, and therefore there was no requirement that he notify SORB of a change of address.
Yes.
Or notify anybody.
I'm sorry?
I mean, you're saying there was 2 points. One was police department, one was did he move? But I take it that it was the Commonwealth's argument at trial that A, he moved, and B, he was supposed to notify the police department and SORB?
No. At trial, it was the Commonwealth's position, this defendant moved his address. And he failed to give notice to the local police department, period. The Commonwealth did not argue at trial that he moved, and he was supposed to give notice to the police department and SORB. They did not argue it.
Okay.
Okay.
Now, for the first time on appeal, they are arguing, we concede he was not supposed to give notice to the police department. We concede that. But
So
we
the
are,
only thing we have to decide is whether or not there was sufficient evidence that he had moved.
correct, Your Honor.
That's the only issue before us.
Yes.
May I interrupt?
Yes.
I'm told that you wanted to reserve 2 minutes.
Yes.
And you didn't tell us that, so why don't we stop here so you still have your 2 minutes?
May
for
I waive it
rebuttal?
then? I didn't realize that. May I waive it?
Yeah, of course you can.
The only evidence there was that this defendant was two things. One, the probation officer's testimony that she went to the defendant's house on a particular day and he was not home. And she received a telephone call from this defendant saying, all is good, I'm staying with a friend. There was no investigation. Pursuant to Commonwealth v. Rosado, that case is similar to my case to the extent that we are dealing with a sex offender who was not at home at his listed address on a particular day. That is exactly what happened here. The defendant was not home when the probation officer went to his house. There is no further evidence that he moved. Commonwealth v. Gray says there must be investigation. Simply learning that a defendant lives at Street A but then moved to Street B is not enough. There must be evidence. Commonwealth v. Bowling says there must actually be a new address. Transitory basis is insufficient. And that to move, since home address was not defined by this statute, a home address requires a greater degree of permanency or frequency than 4 nights in Bowling. Here we are dealing with the defendant was not home at a particular time. I would respectfully ask that the court rule in the defendant's favor, and I rest on my brief. Thank you.
Thank you, counsel.
Good morning. May it please the court, my name is Elizabeth Sweeney on behalf of the Commonwealth. The Commonwealth does concede that the defendant, as an unclassified sex offender, was not required to register with the Barnstable Police.
Was that,
What
I
was
know
the
the
trial?
issue, yeah, was.
At trial, the Commonwealth argued two theories. First, that the defendant was required to register with Barnstable Police. And second, that the defendant changed his address without notifying SORB or his probation officer.
It talked about SORB as well as the police?
They did. In the transcript on volume 2, page 22, the ADA's argument, he states, the probation officer stated affirmatively on her direct examination that the defendant was not living at that address on July 21st. And he argues that he did change his address without notifying the police. So we addressed that issue at trial. And
About notifying the police?
Not notifying the police and SORB. I'm sorry, I misspoke.
He says that right there?
Yes.
Both police and SORB?
If you review the prosecutor's closing argument, pages 18 through 22 in volume 2, he does argue that the defendant changed his address without notifying probation and that the probation officer did not receive any information from SORB.
So this is one crime, two theories.
Yes.
All right, so what did the court, just
court-
generally return a verdict of guilty?
Yes,
And you concede that one of the theories is no longer viable?
we do concede that.
So we have to look at the second theory and see if that's viable, is that right?
Right, correct. And if you review the second theory, that the defendant changed his address without notifying SORB within the 10-day period, on May 20th, 2011, the defendant filled out the SORB packet with the probation officer. She went over it in detail. She testified that she filled it out for him and he signed it. On July 14th, 2011, on volume 1, page 18, the probation officer states that the defendant did not report to a meeting. And on July 21st, 2000...
That was when she canceled the
Yes.
meeting?
She canceled and asked him to reschedule.
But she never actually communicated directly with him, she just left a voice message for him.
She did leave a voice message, and he did not
And
show
there
up.
was no further evidence that, she communicated directly with him.
Correct. However, on...
Voice message left.
I'm sorry?
Where was the voice message left?
The record is silent as to that.
So we don't
information.
know.
And what was in the
Number,
voice?
I'm assuming, if I'm going off the record, the information that he provided when he filled out the SORB packet with her.
Go ahead.
In terms of what was the message, did it tell him when to come to her office?
I believe she apologized that she was unable to make that meeting and asked him to go to her office.
But
It
when?
didn't provide a day in the record.
not?
It did not provide a day. However, on July 21st, 2011, she visited the defendant's home, and he was not there.
Did she advise him in advance that she was going to be there at that point?
The record, again, is silent as to that information, and
Just showed up,
she's-
basically.
I believe so, yes, which is
And
under
he's
his
expected to be
conditions.
home all the time?
No, but she can, as she did, she called him and on July 14th and said that they needed to have a meeting. He never got back with her. And so on July 21st, she arrived at his house. He was not there. And later that day, the defendant called her and said, "All is well, I'm staying with a friend." 2 days later, within the 10-day period for failing to register, she requested a warrant for failing to register.
So if somebody watches the Super Bowl and has too much to drink and decides to sleep over and is therefore staying at somebody's house, is that sufficient to say they're in violation?
I would argue that no, that is not sufficient to say they're in violation. However, that's not really the facts that we have in this case. There's a significant pattern of July 14th, the defendant did not report to the probation officer. She visited his home on July 21st. He was not there. And later that day, he called and said, "All is well, I'm staying with a friend." There's a consistent pattern of not responding to probation and not being home.
Well,
But I mean, that may be a violation of his probation conditions, but why is that a separate crime? He's not home on a certain day, and then he says, "I'm staying over." That's all you have.
Not necessarily. He didn't report to probation on July 14th.
Yeah, but you just told me that she didn't tell him when to come.
Correct. She didn't tell him a specific day or time. However, when she showed up, as she can do as a probation officer, to see if he's staying at his address as a sex offender that's unclassified.
No, but you were said he didn't show up at her office on July 14th. How was he supposed to know he was supposed to be there on July 14th?
It's my understanding in the record, and I believe it's pages 17 to 18, that he was aware that they were having meetings that week.
Now, focusing on July 21, you said he called later in the day.
Yes.
All right. What caused him to call?
That I am not aware.
He must have known that she stopped by?
Again, the record is silent as to that fact.
Give a note or anything? And he was,
There's
okay, so
nothing
I
in the
don't-
record, I'm sorry. However, he did say, "All is well, I'm staying with a friend," when responding to the fact that he was supposed to meet with her. And
He wasn't supposed to meet with her on 7/21.
he wasn't supposed to meet with her on 7/21, he was supposed to meet with her on July 14th. And
Well, isn't the fact that he left a message some indication that he was trying to get back to her?
indication that he was trying to get back to her, however.
She wasn't
if you
there.
look at- Right, she wasn't there. But if you look at the substance of the message, "All is well, I'm staying with a friend," in response to discussing his issues with his probation officer, that in the Commonwealth's position, and also found at trial, was sufficient to uphold a verdict of guilty that he changed his address.
What's required? How much staying is required in order to trigger the obligation to report a proposed change of address?
Well, I don't think it's necessarily that staying is required, but the fact that there's a consistent pattern, not only with that message of "I'm staying with a friend,"
But if you
of
stay,
failing
but
to-
if you stay with someone for 2 days or 3 days, do you need to report that in advance?
No, it's a change of address. However, again, if you review the context of this message with the fact that defendant did not report to probation on July 14th, and she visited his house, he was not home. Between the 21st and the 23rd, he didn't report to her at all after leaving that message of "All is well, I'm staying with a friend," when he failed to show up for his appointment. That's sufficient to uphold a verdict of guilty for failing to register. And
Failing
the
to
judge,
register, not, I mean, oh, you're saying, but failing to give notice of a change of address.
correct.
Don't you have to show for a change of address that it's either 14 days in a year or 4 days in a month?
I believe it's 10 days for unclassified sex offenders.
Okay,
my
but anyway, you've got one.
I believe that we have from July 14th to July 23rd, as the defendant did not report to a probation appointment, and he was
You didn't have
significantly
an
not.
appointment,
It
you've already
wasn't
said
failure
that.
to, she canceled the appointment that she had with him and left a telephone message saying that he should come into the office, but doesn't say when he was supposed to come into the office.
Correct, that is what happened. However,
You're asking for enormous numbers of inferences to be drawn in the Commonwealth's favor.
I don't believe that I'm asking for any inference other than the fact that he said, "All is well, I'm staying with a
No,
friend."
that
and-
was in terms of the dates that you have to prove. On July 14th, you say that that's when it all starts running, but I'm having trouble seeing that it is when it starts running.
And July 14th is the first day that the defendant didn't report to his.
She canceled the appointment with him.
She did cancel the appointment with him.
Yes.
However, his response to that was, "All is well, I'm staying with a friend," and then 2 days after that, she asked for a warrant. There was no further communication between him to her as to rescheduling this appointment and where he was staying. There's a
So
significant.
you're putting importance on the fact that after she got a warrant, he didn't contact her?
I'm putting importance on the fact that between July 14th and July 23rd, the defendant consistently was failing in reporting where he was to his probation officer. He wasn't home on July 21st, and he wasn't in communication with her between July 14th and July 21st when she showed up at 55 LaFrance Street where he was living. And later that day, his message was, "All is well, I'm staying with a friend." There's only so much that a probation officer can do. She did show up at his house looking for him, and then he just leaves a voicemail. I would argue that that is not, that suggests, as the trial judge found, that the defendant changed his address without notifying probation or SORB.
The Commonwealth has the burden of proving this beyond a reasonable doubt?
Yes. And that the trial judge did find that the Commonwealth had proved this beyond a reasonable doubt. And again, it's a sufficiency evidence claim. If you apply the Lattimore standard, I suggest to you that the Commonwealth has met its burden in reviewing the record and the consistent pattern of the defendant not being home, not responding to probation, and then leaving a voicemail of saying, "All is well, I'm staying with a friend." And if there are no further questions, I rest on my brief.
Thank you, Counsel.
Thank you.